Mwamuye, to begin by confirming your county.
My home county is Kilifi County.
Your ethnicity.
I am Mijikenda.
The commissioners will engage you with the questions. We have looked at your CV and your sample writing and all the documents you have sent, but we will engage you with a few questions, and the first set of questions will be asked by Justice Ishara.
Thank you, my lady.
Thank you, Honorable Chair. Wakili, looking at your CV, it would appear like you now have slightly over 15 years of experience ever since you were admitted. Is that correct?
That's correct, my lady.
Right. And majorly you've been in private practice.
Yes, that's correct, my lady.
Right. Now, we have about 100 candidates, actually to be specific, 100 candidates, whom we are interviewing for the position of judgeship in the High Court. Can you tell us, say in 3 minutes, what you've been doing ever since you qualified that makes you think you are the right person that we should take for the position of High Court judge?
Thank you, my lady. For the position of High Court judge, I believe the Commission wants to see certain attributes such as professional competence, good judgment, diligence, and the ability to work well with others, amongst others. I began my career in the Kenya Revenue Authority in 2007. I was a revenue officer, and I eventually transferred to the Legal Services Department, where I was a legal officer. During that time in the public sector, I acquired certain skills. The role of revenue officer and legal officer also had some administrative and managerial roles. So I was able to garner this experience, and then I transitioned that into the private sector from 2012 to date. Aside from running a law firm, I've also held positions in statutory and in statutory and constitutional tribunals, which I believe have prepared me for the role of Judge of the High Court. I am familiar with writing rulings and judgments during my stint at the National Environment Tribunal from 2016 until 2023, and at the constitutional tribunals. I'm well versed with the expectations of a judge.
Thank you for that. So if you are to be the lucky candidate and you are taken as a judge of the High Court, what is it that you would want to do differently from what you've generally observed happening in the judiciary when it comes to judgeship?
Thank you, my lady. There are two things that I've noticed about how certain matters are conducted in the High Court. The first is delay. What I would propose to do is I'd make more use of extempore rulings for straightforward matters, rather than having to retreat and write for 14 days or so and then deliver those rulings. Delay can also be mitigated by making better use of ICT, such that instead of having to handwrite something and then have someone else type it, or perhaps yourself type it, you type whatever it is that you're doing directly into the computer. The other issue that I've noted that I would do differently is how we project the image of the judiciary to the public. It's a small thing, but where a court does not start on time and an explanation or an apology is not preferred, that sends a very negative picture to the public. As advocates, we understand that life happens and sometimes a judge is called at the last minute into a meeting, but our clients are not that familiar with these processes, and so I would do that differently.
So that is as far as the negative aspects are concerned, but I'm sure it's also possible that there are one or two things, if not more, that you would like to emulate from what you've seen happening in the judiciary, particularly when it comes to judgeship, and possibly you could tell us if there are judges that you admire, the way they conduct themselves, etc.
Thank you, my lady. When I began practice in 2008, we had a very, very different judiciary. It was not uncommon for judges to be overly strict and sometimes maybe even unfair. But I'm happy to say that we have had a lot of progress, a lot of transformation, and this is seen in how the values of humility and courtesy are integral to the role of a judge now. There are a number of judges that I admire. Some of them are in this room. What I admire most about them is their diligence, their calmness, the way they are methodical in handling their briefs, and also particularly when I used to appear before Justice Majanja at the beginning of my career, how Justice Majanja would mentor me and show me that I have to do things in a particular way. There was one case where I asked for 14 days to put in a replying affidavit, and Justice Majanja said, no, you can't do that. You can file something by the afternoon. And that encouraged me to go back to the office, get the officers, have an affidavit drafted, signed, commissioned, and filed.
Thank you, and that's so much from me, but just a little issue, and I hope you don't mind me asking you this. When you say you are a Mijikenda, which particular subsector of the Mijikenda are you? Giriama?
I'm a Chonyi, my lady.
Chonyi, okay.
Yes, I'm a Chonyi, my lady.
Thank you.
Okay, thank you. Just a few questions. The first one is this is the second time you've appeared before us. You were here last time, and as a feedback, actually you did very well. It's only that the positions were few. It was not because of any lack of skills. You performed exceptionally well. Now, what is driving you? Because there has to be something that is driving you into wanting to cross over to the judiciary by appearing the second time. You didn't lose hope. You still thought it was good to give it a shot a second time.
Becoming a judge is a calling that I feel very personally. It's been a dream that I've had for as long as I can remember, and it's informed all the educational and career choices that I've made. My approach to setbacks is not to let them overcome me. It is to redouble my efforts and come back strong, and hopefully my application is even better than last time.
From when I look at your CV, based on the various areas that you've served, would you demonstrate to the Commission what are the key attributes that you think you've garnered, in terms of experience that makes you judge ready, in the sense that if you're given this appointment, the learning curve will not be long?
Thank you, Vice Chair. From my sample writings, I believe I demonstrate that I've had a wide practice in different superior courts, as well as before tribunals, as well as experience in writing rulings and judgments. My fifth sample writing is a decision of the National Environment Tribunal, in which I was the acting chair. I conducted all the proceedings, and after conferencing with my two colleagues in the matter, I wrote the entire judgment. So I believe that demonstrates that I'm judge ready.
Now, my final question. In the process of recruitment, even for us as a commission, sometimes it's not easy to say with reasonable measure of certainty that the person you're going to give that appointment will be able to pass the master once it comes to doing the actual job. It's kind of sometimes a hit and miss. We get it right many times. Also sometimes we get it wrong. Now, what would you say that you have now as Bahati Mwamue that would give us some confidence that the moment we say that we are going to forward your name for appointment as a judge, that will be among the pool of those ones that we can say that we got it right as a commission? Three key things.
Thank you, Vice Chair. Three key things on that. First, I've demonstrated my ability to deliver in high-profile, high-pressure situations, both in statutory and constitutional tribunals. Secondly, I believe in continuous learning and improvement. The judge I will be, God willing, in 2024 will not be the judge that I will be at 70 when I'm retiring. This requires you to have an open heart, an open mind, humility. If you need to ask someone for advice, consultation, that is something I do on a daily basis. Lastly, it is about integrity. I have served in places that have been profiled about having some integrity issues, but I have discharged myself very well in those areas, and there has never been any integrity question to my name, and there never will be.
Yes, following on those questions my colleagues have asked, I would want to go straight to the High Court, which, as you know, has various jurisdictions. In fact, when we met stakeholders to prepare for this interview, they told us there are about 12 or 13 jurisdictions of the High Court. If you can tell us about 5 of them, the jurisdictions of the High Court.
Thank you, my lady. The High Court has unlimited original jurisdiction in criminal and civil matters. It has a supervisory jurisdiction over subordinate courts and public bodies exercising quasi-judicial roles. It has appellate jurisdiction over constitutional tribunals for the removal of office holders other than the President and judges of superior courts. It has jurisdiction to interpret the Constitution and apply the same to statute. It also has the jurisdiction to investigate whether the Bill of Rights is threatened, infringed, violated, or in any other way being contravened.
Thank you. A survey was done on the judiciary sometimes regarding access to justice by the members of the public. And the survey revealed that only 10% of Kenyans are able to access formal justice systems, the magistrates' courts, the High Court, Court of Appeal, and the Supreme Court, meaning that a huge segment is left on their own devices. As a judge, what would you do to make sure that we broaden the doorways to justice?
Thank you, my lady. As a judge, I will promote the multi-door approach. It requires the recognition that the formal justice system may be too expensive or too inaccessible for most Kenyans, and aspects like conciliation, mediation, whether court annexed or not, alternative dispute resolution, or even alternative justice systems at the community level are ambiguous or not capable of interpretation. For example, the Court of Appeal applied that standard to the definition of robbery with violence, looking at whether it was very clear what constitutes robbery with violence. Another is a process examination, examining whether it is a matter that required both houses of parliament to pass it, but it was only passed by one house of parliament. That would be an invalid statute. Third is on public participation. Quite a number of statutes have been invalidated because they did not meet our public participation requirements. The fourth is that it derogates from the essential nature of a fundamental right of freedom in a way that is not contemplated by Article 24. And lastly, it is something that grossly contravenes a specific provision of the Constitution.
Thank you. I think I'm happy with that. The next set of questions will be asked by Justice Majanja.
Thank you, my lady.
Last time you were here, you recall. Last time you were here, you recall one of the commissioners took you through what happened at the Net Tribunal. The issue you had with the chair at that particular time.
Yes, my lord.
And I'm sure you've had time to reflect on what happened.
Yes, my lord.
What lessons do you draw from that experience? Perhaps you tell us what happened, and then what lessons do you draw from that experience that would be relevant to you as a judge if you're appointed?
Thank you, my lord. There was an internal breakdown within the National Environment Tribunal at the time when the then chairperson, the Honorable Dr. Dwasi, was coming up for renewal. Myself and my colleagues had some concerns about her conduct as the chairperson. In my exchange last time with Justice Wasame, he was able to make me realize that I did not fully exhaust the internal mechanisms that were available to me, and we rushed to the JSC. I should have gone to Dr. Dwasi, explained my concerns to her, given her an opportunity to respond before coming to this commission. It is something that I learned, I regret. I did apologize. I sent her an apology email. I didn't have her telephone number, and it's something that will not happen again.
Okay, that's good. At NET, one of the you were writing judgments. What were some of the challenges you faced in writing judgments, and are there any lessons learned that would assist you in this job you're applying for?
At NET, our biggest challenge, my lord, was that unlike what is in the mainstream judiciary, we would not have documents in soft copy. Environment cases at the National Environment Tribunal level are often very complex, and it's not uncommon to have 10, 20 volumes of reports. So what we had to do is to go through all of those reports. We had to learn how to leverage on our skills. What I did for the matters where I would be asked to write is I found out that we have software that you can scan the bundles, turns it into a Word document, which makes it easier for you to copy things and put them into your final judgment.
Okay. And finally, away from the two questions I've asked, can you tell us the difference between appeal and revision in the context of the Criminal Procedure Code? The difference between an appeal and a revision.
Thank you, my lord. A revision is where the Superior Court, in this case the High Court, is looking for an error manifest on the record. It is different from an appeal, which is looking at the merits as well as the law on the decision. There are certain things you can do in an appeal that you cannot do in a revision. For example, you cannot revise an acquittal into a conviction. But on appeal, you can vary the sentence, you can enhance the sentence, you can reverse an acquittal into a conviction.
And how is revision invoked or exercised?
It used to be that the judge would go over records and then revise. But now we apply for revision.
You can apply, you can go over records. Party can apply to you. And for example, if you saw you were sitting in Machakos and there was a newspaper report that a child had been convicted and sentenced to jail for 10 years, a child that's an underage, what would you do in those circumstances?
I would call for the file from the subordinate court to substantiate whether the newspaper report is correct. The power of revision still remains that you can revise. You can revise that as the High Court.
And in such a case, what would you do in this particular case?
The child has been sentenced to 10 years, my lord.
In prison, yes.
Yeah. Under both the Constitution, the Bill of Rights, as well as the Children's Act 2022, incarceration of a child is a last resort. So I'd want to go through the proceedings, particularly the mitigation, as well as the thoughts of the magistrate thereafter as to why this particular child had to be incarcerated, and also for 10 years, which is a lengthy period of time.
Okay. And lastly, I saw that you've been a member of tribunals investigating judges. I think 4 of them. You appointed to 4 of them. What is the greatest lesson you learned through that process?
My lord, the greatest lesson I learned is that the job of a judge of a superior court requires you to act with utmost good faith. But even if you act with utmost good faith, if you cannot demonstrate that, you can get yourself into an uncomfortable situation.
Thank you. Thank you, Chair.
Council, I have a few questions for you. I noticed that you come from a minority community, but I see your address is in Nairobi, which I assume you practice from Nairobi substantially. You didn't want to go and have a base in the coast where maybe could be of immediate help to the community? Or it is your area of practice that makes places you here?
Thank you, my lord. I am an active practitioner in commercial and tax matters, as well as in civil matters and arbitration, and most of my work is in Nairobi, but I do travel across the country.
Okay. Yeah. At the start of your interview, you said that about writing. You mentioned about writing and what you called extempore rulings, and extempore rulings are quite rare presently. It used to be quite common earlier days. In what circumstances would you think it is appropriate to give an extempore rulings? And maybe you can even, for the purposes of us understanding what that means, you can define what that extempore ruling means.
An extempore ruling is a ruling delivered on the spot at the same time, extempore, at the same time. What I would like to be doing is just typing it directly in, which then makes it easier for me to convert that, sign it. I would sign it still, and then upload it onto this system. For some of the matters that are fairly well canvassed, like injunction, you have already read through the file. When parties have come before you and you've conducted the hearing, you can take 5-10 minutes to apply the GALA three-pronged standard to that and deliver a very quick ruling.
Okay. All right. Thank you for that. When a party, now assuming that you appointed a judge and now you are a judicial officer, when a party applies raises a point of law in their pleadings, and it is a matter of, say, jurisdictional nature, when the matter comes up, whether it is an application or the judgment itself, the hearing itself rather, how would you proceed with a point of law that questions jurisdictional issue, like particularly jurisdiction itself, or even things a point of law like limitation of actions?
The question of jurisdiction takes primacy over everything else. If it is raised, and given that we now are a system where we have a lot of inbuilt protections, I would ask counsel to, if there's nowhere where it's written in their pleadings, to briefly explain it. Then I would ask them to reduce it into a preliminary objection so that the other party can consider it. I would also encourage quicker dispensation of preliminary objections by requiring that you file your PO together with your submissions, so the other side replies very, very quickly.
Yeah. Okay. Now, in practice, in actual practice now, particularly in the Court of Appeal, sometimes, and many times even in the Supreme Court, because of time exigencies, you find that a point of law has been raised. It's quite vital, it's quite important on the face of it, but at the same time you have to save time so that to dispose of the matter quickly. And courts have adopted a hybrid situation whereby at times they allow the matter to be heard in entirety, and then the point of law is subsumed in the judgment. But it becomes the immediate matter, the matter to be dealt with at the outset. What do you think of that approach?
Yes, Judge, it's correct. I wouldn't require a PO to be filed in all circumstances, which is why I would ask the counsel to explain themselves. Some preliminary points on jurisdiction can only really be discovered within a hearing. A PO may not be the best way to bring out a challenge to jurisdiction, because sometimes you need evidence, contested evidence, to test whether or not the court has jurisdiction. I could give an example that I've just experienced in the Environment and Land Court on whether something was supposed to be filed in the ELC or whether it was supposed to be filed in the High Court. Because of the evidence, it could not have come out at the preliminary stage. So what happened, and which is what I would do, the judge handled that as the first issue, found that it was not an ELC matter, and then did not proceed thereafter.
Thank you. Lastly, I've looked at your sample ratings. I think the decision you referred to, sample number 5, your judgment, which was a collegial tribunal, where you delivered together with 2 others, very prominent counsels, 2, and where I believe you said that you led the bench. I think you did quite a good job. It's quite articulate and well done. And I think this is evidence that you can make a good judge based on such writings.
Thank you.
Now the question is, and this is part of writing, the issue of course is at the discretion of the tribunal or the court. In this case, you ordered that cost be borne by each party bears their cost, but while you are exercising your discretion, you didn't give the reasons why.
Thank you, my lord. In the Environment Tribunal, things are slightly different from the mainstream courts. We were bound by the National Environment Tribunal rules, which require that if the tribunal is going to make an award of costs, the parties must be specifically given the opportunity to address the tribunal only on the question of costs.
Nobody pursued it in depth.
What I was trying to do in that matter, and this happened quite a lot, is when you then invite persons to come in on costs within your judgment, you simply elongate the matter and the dispute. The rules allow any party who is aggrieved with that order of costs to then come for review to the tribunal only on the question of costs, and we'd have had that application.
Okay. Thank you very much. I wish you all the best.
Thank you, Judge.
Thank you, Chair. Good morning once again, Council.
Good morning.
I agree with Judge Ibrahim that you write very well, though my concern is that we only have 5 decisions that we have, so maybe my judgment may not be the correct one. You appear to be a textualist in terms of you want to, well, this is what the law says, and you have to limit yourself with what the law says. Am I right with that observation?
Thank you, Commissioner. As you've said, we only have opportunity to give 5 writings.
Yes.
The writings I've submitted were in matters where all I was being called upon to do is to apply the text of the law to the facts of the case and not go beyond that. I am still a very dynamic thinker. In one of the sample writings that I've submitted, the employment and labor relations one, it's the 4-page one, there was a counterclaim. Now, counterclaims in ELRC are very rare because a lot of counsel do not believe that you can successfully argue a counterclaim. But I did argue a counterclaim, and it was successful, and the claim was also dismissed. So I am a dynamic thinker.
Oh, okay. Again, the sample writing you have shared, the mental health one, I don't want to mention the names of the parties for obvious reasons. What are the rights of persons with mental disabilities have under the regional and international human rights instruments?
Thank you, Commissioner. I'm not very familiar with the specific rights under regional or international treaties. It is something that I will definitely, after this, go and research into. In this particular case,
you don't have to go to the details.
Yes.
Obviously,
In this particular case, we did not need to go out beyond the Mental Health Act. It was a very fact-based case about whether the patient was suffering from a mental impairment that required the patient to then be put under guardianship.
And that's why when I tell you you're a bit a textualist, you just want to say what the law says. You don't want to make reference to any other document or information out there. Because to the best of my knowledge, I know persons with mental impairment have the right to supported decision making, including legal capacity. So you may need to go and read around that, because there's been concerns that that particular provision of the law is being abused, and persons with mental impairment are taken advantage of by just going to court without them saying what their needs are. That's just for you to think or read further. The other bit still on that particular case, in your submission, paragraph 8.11, this is more of the use of language. You have indicated, allow me to read part of it, is that patient's own application is a glaring example of her dangerously diminished mental capacity. Issue of language. Here you're speaking about a person with mental impairment. What does that language communicate to the person with mental impairment, or to generally Kenyans? And we know mental issue is something as a country we are grappling with. Show of compassionate, the use of proper language.
Thank you, Commissioner. For Mental Health Act cases, and we derive a lot of authorities from England because we subsumed their act at the time into Kenya, you have to prove certain ingredients. That the patient is a danger to themselves or to others, that they have diminished mental capacity is another standard, they cannot understand what is going around them, and they cannot care for themselves. So when I said dangerously diminished mental capacity, I was applying the ingredients that are required for a finding of guardianship under the Mental Health Act.
And you still insist that that language is okay? understanding that we need to be compassionate to persons with mental issues. Is there a better language you can use? If you are the judge writing that decision, will you use same terminologies?
No, as a judge I would not use the same terminology. The way a counsel can speak is not the same way that a judge should speak. So I would not have used the word dangerously. Diminished mental capacity can be a fact, that one a judge can safely say, but I would not have used the word dangerously, despite it being a word that is used elsewhere.
Okay. Lastly, is incompetence is among the grounds to which a judge can be removed from office. How would you gauge incompetence of a judge?
It is, from my experience in the Article 168 tribunals, you have to apply a very fact-based approach, circumstances. An individual circumstance particular to that subject judge. It is not possible to say sweeping what would be incompetence. Elements of delay could come into incompetence. A judge who is frequently being overturned by the appellate court could be pointed to incompetence. Looking at decisions that have glaring legal faults, all that could be incompetence. I would be guided by what the JSC petition has stated as the grounds, and then I'd examine that based on the law. But if I may just add, I think that the role of the 168 tribunal is not to be an appellate court to decide whether or not the judge got things wrong. So we'd have to tread carefully there.
So you would agree with me that it is not right for a judge or a judicial officer to hide behind decisional independence, and in actual matter of fact there is an element of incompetence?
Yes, I would agree with you. We have a very transformative and accountable constitution now that requires judges to be transparent and accountable to the people of Kenya.
Okay, thank you very much, and wishing you the very best.
Thank you, Commissioner.
Thank you, Chair, and welcome again, Honorable Andrew.
Thank you.
Now, like you've been told, when we were preparing for this exercise, we involved the stakeholders, and they told us that they would want to see a judge who understands the complexities of the judicial system, including the challenging environment and power dynamics. So what makes the judicial system complex? And if you are appointed as a judge, how will you navigate these complexities and the challenging environment that the stakeholders told us about?
Thank you, Commissioner. The judicial system is complex because it involves various legal instruments and principles, some of which are not very simple. You require multiple actors within the criminal justice system or the civil justice systems. You must also operate within an environment that is not just the judiciary or law. The judiciary does not exist in a vacuum. So you operate in a governmental and a social and a legal and even a technological space. Oh, sorry. It is to leverage on the resources that are available to you. If, for example, looking at technology, I would leverage on what is available to us now through online filing, through CTS. On other aspects such as the political aspect of it, it is to make sure that in my decisions there is no partisanship or coming into any political dispute that does not have a legal basis before me.
Okay. Now, judiciary has also been implementing a transformation agenda since 2010. You've seen where the judiciary was before the promulgation of the Constitution and where we are today. So could you share with us the measures and the strategies that you would recommend or you would bring on board to assist the realization of this journey?
Thank you, Commissioner. Transformation requires support from every single member of the judiciary as well as from stakeholders. As a practicing counsel, what I advocate for is for the judiciary to incorporate more of our opinions and the opinions of other stakeholders in this transformative journey. The bar bench committees and court user committees are not, in my opinion, being used to their full potential.
Lastly from me is that, you're aware that recently the Honorable Chief Justice rolled out e-filing, and the judiciary is now leveraging on ICT. So what risks do you think the judiciary is going to face on this move, and what interventions would you recommend?
Thank you, Commissioner. Yes, I did, Commissioner. There are a number of risks that are inherent in ICT. These include system outages, deliberate malactions like hacking, and also data loss or data corruption. As we roll out the ICT element within the judiciary, we must still have safeguards and fallback measures in case any of these risks occur.
Thank you, my lady. Good morning once again.
Good morning.
Okay, I was going through your CV. You have worked with us, as you mentioned, in the Net Tribunal.
Yes.
And you currently run your own law firm.
Yes.
While working at Net, were you submitting returns or were you signing the PMMU that the judiciary has for performance measurement?
Yes, we were, and we received a number of awards twice. We were rated as the best medium-sized tribunal.
So you're filing your returns in terms of your daily work reports?
Yes.
Okay, were you supplied with a copy of what you had submitted?
No.
By people? You have not been given a copy, because I also don't have one, but we'll look at it. But I wanted to see whether you meet your targets in terms of performance. So you said you once or twice won an award.
Yes.
In what category?
Medium-sized tribunals.
In doing what? Is it the case clearance?
Yes, it was case clearance and overall as well.
Oh, okay. My second question is the overriding objective in case management in criminal cases is to hear case and determine cases in a just and expeditious manner. How do you go about achieving that in a criminal case?
You ensure that at the case management stage, at the pretrial conference, you have secured all the imperatives that are necessary. The first imperative is you're making sure that only the matters that cannot be settled out of court or be diverted outside of court activities are going to hearing. Secondly, you're ensuring that the rights of the accused to have all the evidence and documents that will be relied on will have already been presented to him have already presented to him or her. Third, you're making sure that both sides are ready to progress to hearing and they will not return you back to pretrial. And fourth, any preliminary issues on admissibility of evidence, etc., have already been sorted out.
Okay. What about touching on the actual trial, the actual hearing? Are there any things you can do at that preliminary stage to ensure that the matter is handled justly and expeditiously?
Yes, Commissioner. You look at giving the nearest hearing date. You also try and ensure that, because it's the prosecution who are going first, that they have as many witnesses as possible on the first day.
Okay. My other question, I'm going to give you a practical scenario, and then maybe you can tell us what you would do to address, rather in terms of case management. So imagine a situation where you are successful as a judge, and you are posted to serve at the family division at Milimani, where they have about 15,000 pending cases, family cases. You will find that a big percentage of those are P&A cases, the probate and administration cases. And in your docket, you find that about 60% of them are cases pending hearing of protests and objections. They're pending hearing of protests and objections. And these cases are about to clock their third birthday, and you know around here we want to be able to conclude cases within 3 years. So we don't want them to go over their third birthday. So could you just give us a practical example of how, or what innovative ways you would apply to ensure that you conclude these cases within that time frame?
Thank you, Commissioner. From my own experience representing parties who have filed protests or objections, when parties sometimes get the opportunity to sit down and discuss the issue, for example, if it's the issue of who should be an administrator, you find that they then come back to court and they say, we have spoken, we have agreed. We can unlock a lot of this backlog by making deliberate efforts to tell the parties, step out of court, take a week or two, discuss, and come back and see whether you've not sorted out the issues.
So one of the ways you'll explore is to see if they're able to agree.
Yes, Commissioner.
Yeah. What other way? Most probably you will find a majority of them will not be able to agree. That's why they're still stuck waiting for a hearing date.
I think, Commissioner, if the matter has to be heard, you have to prioritize. You have to age your docket, prioritizing the older matters and working towards the newer ones. There may not be a shortcut available. You just have to go and hear those matters.
Okay. My last question. You have been practicing majorly in Nairobi.
Yes, Commissioner.
Yes. And you look quite young, so I presume you probably have a young family.
Yes, Commissioner.
Just to determine whether you are ready for what it takes to be a judge. You may be successful and become a judge, and that would mean then in your docket you have about 1,500 cases that you are required to handle. It would mean that you have to live a very restricted lifestyle. You probably currently engage in social media. You have to rethink how you engage on social media, how you engage with friends. You may have to lose some friends because that calling may require you not to socialize as you have been doing as an advocate. You also have to be ready to welcome probity into your life because you more or less become public property. And also you are likely to be transferred somewhere very far, or rather posted somewhere very far away from Nairobi. I don't know how well prepared you are to handle that kind of situation.
Thank you, Commissioner. May I begin with the second aspect, being transferred away from Nairobi. This is something I was prepared for since 2009 when I completed the Nairobi-based phase of the KRA training program. It is also something that I've discussed with friends who work in the judiciary and serve outside of Nairobi. They have given me insights into what you have to do. You have to remain an active participant in your family life, and it is something that my wife and I have discussed, so I'm ready for that. As for the social changes that come with becoming a judge, I am naturally an introvert, so I don't have a very large social circle, But I do also believe that if you put yourself up for the position of judge, you have to accept everything that it comes with, and you have to be ready to make the necessary sacrifices. And I'm ready to make those sacrifices.
Okay. Thank you, and I wish you well. Thank you very
Thank you.
much.
Thank you very much, CJ. Now, thank you for the answers you've given so far. For the other questions, mine is on your leadership abilities, and I would like you to tell us what achievements can you describe to us which are directly as a result of your leadership and vision.
Thank you, Commissioner. I believe that a good leader is one who grows, empowers, and inspires their colleagues and teammates. Since becoming a pupil master, I have deliberately grown persons from being pupils into becoming advocates, mentoring them until they've established their own law firms. I also proactively engage them so that I am finding out whether or not they are doing well and what assistance I can give them. I'm proud to say that I've done this successfully for quite a number of younger advocates, to the extent that my own personal litigation is handled by them, as well as my own personal civil matters like conveyancing.
Chapter 6 of the Constitution talks about leadership and integrity. What are the guiding principles of leadership and integrity?
The guiding principles of leadership and integrity are that you must be faithful to the Constitution, uphold the Constitution, and apply it to your own conduct. You should treat the position as a position of servant leadership, not you being a ruler over the people of Kenya. You should respect the people of Kenya. You should avoid any conflict of interest between your personal interests and your official role or your public duties. If one arises, you should be honest and proactively disclose that such a conflict exists, and then remove yourself from that situation. You should also abide by all applicable standards on financial probity and others.
Yes, further, Article 73 of the Constitution also talks about the responsibilities of leadership. Can you remember any?
Yes, I think the most important there of the five is that you at all times hold yourself out in a manner that brings honor to the nation and brings dignity to the office. I think that in Article 73 is the basic norm, and if you apply that, everything else you'll be able to very easily achieve.
Thank you, Chair.
Thank you, Honorable CJ. Bwana Andrew Bahati Mamuye. The institution of the judiciary has been seen to be a weak link in the fight against corruption. Now, if you're successful in this bid to become a judge, please tell us practical ways that you're going to put in place to ensure that this vice is minimized or eliminated completely.
Thank you, Commissioner. The fact that the judiciary is seen as a weak link in the fight against corruption is not actually attributable to anything that the judiciary is doing wrong. More often than not, it is because the judiciary is the most prominent actor, and it finds itself being blamed for the actions and omissions of other players in the criminal justice chain. So, for example, topically, we are discussing as a nation the question of acquittals in anti-corruption cases. A court can only determine the case that is before it based on the evidence that has been brought, that has been led by the prosecution, and apply that to the applicable laws. If that evidence is not to the threshold required by the law, then the natural consequence is an acquittal. And what I would do as a judge is I would be very firm on some of the practices that have become a little bit commonplace in this. So if a matter is going to be dismissed because witnesses are not showing up, I would not be a passive actor in that. I would insist, where is this witness? Were they bonded? Can we issue summons? It would be a last resort that a matter is being dismissed and an acquittal is going to be entered because of non-attendance of prosecution witnesses.
And what would you do if you're posted to head a station in regards with the staff that will be working under you?
Thank you, Commissioner. As a head of a station, you are accountable and responsible for the implementation of the judiciary's anti-corruption framework. So it is supporting the activities of the Judiciary Ombudsman, the Inspectorate Unit of JSC, Internal Affairs and Audit, and the others. It also requires you as the leader in that station to lead by example. You must be an integrity champion in the way you behave, and you must portray and make it very clear that you have a zero tolerance stance on it.
Okay. Now, the Constitution of Kenya assumes the theme of good leadership and integrity throughout its chapters, as well as other acts. Would you just name 3 sections of the Constitution or acts that talk about leadership and integrity?
I would look at Article 73, Articles 77, and outside of Chapter 6, I would look at Article 232 on the values and principles of public service. I'd also look at Article 10.
Okay, thank you for that. My final question, we have seen your profile, which is very impressive. We have seen some of the recommendations that your professional referees have given, but there's something that we really do not quite get out of it. If today I walk to Bahati Mwamuye and Company Advocates, what is the one thing that the people that work under you would tell me they don't like about you?
Don't like about me? I don't think my colleagues have ever said they don't like me. One of the things that I struggle with, particularly younger advocates and with pupils, is explaining to them that the way you behave in the office will also affect the way you behave with clients and the way you behave with in court. So you are a full-time advocate of the High Court. There is no off button. Similarly, if I'm privileged to become a judge, I would apply that same standard of being a full-time judge. So specifically what perhaps my colleagues would say about my strictness on that is we have a dress code, and from time to time you find that people are wearing these comfortable office, not office, home shoes. They look like sandals. Slides, yes, thank you, slides. I say to my colleagues, you have to be professional and presentable at all times. You cannot let your dressing code down, because once you begin that, you will then have problems further down the line.
So because of your strictness, you run into conflict with these people?
No, it's not conflict. It's only on that point. I think when we have generational gaps, because there's an age gap between me and the pupil and my associate, they have a different worldview and they have a different way of doing things. What I try to do is to balance those two. I say, yes, you're young, and for you this may not seem like a big deal, but in the legal profession, the way you dress is very, very important. And if I am to give my pupil any advice, it is that you cannot have lower standards than your competitors, because the other pupils will ultimately be your competitors competing for clients with you. If your dress sense is not sharp, you will not get good clients.
In your view, does that approach work?
Yes, I'm not someone who shouts and berates someone. I don't also embarrass you in front of your colleagues. I call you into my office. I ask you, I've seen you wearing slides. Is there a medical issue? Is there something? And then you say, no, I just feel more comfortable. And then I explain my perspective. I invite you to explain yours, and we see if we can't have a middle ground. And that middle ground was achieved with us now having a dress down Friday.
Okay. Thank you. Thank you for that.
Thank you, Commissioner.
Yes. Council, I see you're doing your masters. How far are you to completion?
I've been doing my project. I've been slightly unfortunate. I've been choosing topics in tax that ultimately become acts of parliament. My first one was that we need a tax procedures code, and then we got a tax procedures act. I'm currently engaging with my supervisor about switching to banking, where I think there's a lot more I can talk about.
Okay, I hope it will not interfere, because if you're successful, you are supposed to hit the road running. How would you balance schoolwork and judgeship if you're successful?
It's just the thesis that is pending. I already have the first 3 chapters. Once those are approved, the next 2 are very easy to do.
Thank you very much, Council, for a very engaging time this morning with the commissioners. I think this brings us to the end of the interview, but before we sign you off, we give you an opportunity to ask us a question if you have any.
Thank you, Madam Chief Justice. Thank you, Commissioners. I don't have any questions. I would just like to conclude by thanking you, particularly for giving me a second opportunity to put myself out there for this job. And thank you very much.
Thank you. We wish you all the best. Keep up the good work that you're doing there. You will hear from us when we complete the process.
Thank you, Madam Chief Justice.
Have a good day.
Good day.
So for the last 17 years, what is it that you've been doing that is relevant to this position? In about 2 or 3 minutes.
Thank you, my lady. First of all, Honorable Chief Justice, Commissioners, thank you so much for the opportunity to appear before you this morning. I was admitted in 2006. I hold a doctorate degree in law. I hold a master's degree in human rights law, both from the University of South Africa. I hold an LLB degree from Moi University and a postgraduate diploma from the Kenya School of Law. My personal values, let me just highlight on that, are number 1, relationships. I'm very intentional about my relationships with God and people. My second value is integrity. I observe that in my public and private life. My third value is continuous learning. I encourage myself to ensure that I upscale.
I don't want to appear like I'm interrupting you, but yes, those questions will come in at some point.
Yes.
But for now, we just wanted you to relate your professional life vis-a-vis this job that you've applied for.
Correct. Let me proceed to do that. I understand that the work of a judge to entail 2 broad functions, my lady and commissioners. The first function is judicial in nature, which involves the ability of a judge to hear a matter, write a ruling that is, or a judgment that is consistent with the law. And for a judge to be able to do that, then they must have the professional competence required. They must have a deep understanding of the law. My 17 years of practice, my 17 years of being an active participant in our court corridors, also as an academic and also as an in-house counsel, has given me the professional competence to be able to discharge that function. I bring with me research and writing skills. I bring with me practical experience from the courts, and I believe those are the skills that a judge would need to be able to do the judicial part of the work. The other side of the work that I understand a judge does is largely administrative. And I want to say that in all the places that I have worked, Honorable Commissioner, I have always held leadership positions. And I believe that a judge should be able, for example, to put together a team that would be able to achieve certain objectives in the station that he or she works. I believe because of my leadership abilities, I am able to put together a team that can achieve certain objectives. If it's case management, if it's dealing with backlog, if it's motivating the staff to achieve certain outcomes, I have the ability to inspire people to work towards achieving those objectives. I believe I have those competencies, and I believe they'll add value to the office of the Judge of the High Court of Kenya.
Right, Wakili, I'm really trying to understand what you've been doing for the last 17 years, and I can break it down further for you and ask you this question. How does your day job look like?
My lady, at the law firm, my day job looks like this. I have to understand what we want to achieve in court on a daily basis with my team. I work with a team of about 6 lawyers. I'm the lead partner in a law firm that has 2 locations, one in Nairobi, the other one in Bungoma County. So on a daily basis, I must know what we want to achieve for that day. I must align my team to achieve those objectives. We must know who is attending to which matter. There are matters that I handle myself. There are others that the other team members handle. And on a daily basis, I must have that information with me. So we do strategy meetings every morning to align ourselves to the objectives that we want to achieve on a daily basis. The law firm that we run is, I would call it a general purpose law firm. We mostly support corporate clients in banking and insurance. So bulk, about 80% of the work that we do is within that spectrum.
All right. Now that you've expressed the desire to join the judiciary in the capacity of a judge, and you being a practitioner, I'm sure over a period of time you've observed certain things that you think if you become a judge, you would not want to be that kind of a judge. What are these?
My lady, the first thing that I have observed in our courts is the problem of backlog. It continues to be a problem even today. As a judge, the first thing that I'll do when I report to work, by God's grace, is I will seek to understand how many matters are within my docket. And I intend, and I believe that the CTS system of the judiciary will be able to tell me how many matters are there allocated to me. And I will seek to understand when these matters were filed, the progress made in these matters, and I'll seek to understand why, for example, some matters are stuck and they are not progressing. If there are matters that need notices to show cause to be issued, I will do that. If there are matters that need advocates to appear before me and take pretrial directions on how to expedite with the matters, we shall do that. If there are matters that we can refer for mediation, we will do that. We'll refer them to mediation. If there are matters that, for example, need to be referred for AJS, we'll refer them to AJS. If there are matters that are dead, because I believe sometimes there are matters that are filed by litigants, and for some reason, the issue is actually resolved out of court. Perhaps somebody passes away. Perhaps as a family they sit down and resolve the matter, but they forget to report back to the judiciary that we have resolved the matter. So I believe there are also some dead cases within our registries that need to be closed.
Wakili, I was very specific, and please try as much as possible not to answer your own question, yes, but to answer the question that you're being asked. The question was, what is it that over a period of time you've observed that you think if you become a judge, you will want to do differently?
And so I'm talking about the issue of backlog. And
how would you want to do that differently?
I would want to use the strategies that I have just said, and also get together the team at the registry to help us decongest the registry by making sure that these matters are actually dealt with. The second issue that I have seen as a challenge in our court systems is what I would call lack of progress in a matter in this sense, Judge, that for instance, we appear before a judicial officer and the other side files a preliminary objection. On the face of it, we can see that it's a preliminary objection that's heading nowhere. I have seen other judicial officers engaging the advocates and asking them to explain why they have filed the preliminary objection, and out of that conversation sometimes somebody withdraws whatever objection they have filed because they can see that they were wasting the court's time. So I will be a proactive judge who will look at whatever is before me and engage the advocates.
So just in a summary form, what special attributes do you bring to the judiciary that would definitely make a difference in the dispensation of justice?
I bring with me the culture of discipline. I'm a disciplined person. I set goals and achieve them. I bring with me a wealth of knowledge from my 17 years of practice, both as an in-house counsel, in academia, and also in practice. I bring with me the experience that I've gotten from research and publications. And with that, I think I'll be a good judge who will build indigenous jurisprudence, a judge who will develop the law through my judgments and rulings. I'll be a judge who will be very sensitive to the current vision that the judiciary is pursuing, that is social transformation through access to justice.
Thank you very much. That's all from me.
Thank you, my lady. Yeah.
Looking at your CV, and you know, you seem to be in very many areas at the same time. Now, my first question would be, what is the key driver in your quest for this position of becoming a judge? Because, you know, you're already doing so many things right now. If you want to become a judge, I don't know what is really driving you into it.
Thank you, Commissioner. My driving force is really to serve this country as a public officer. I've always wanted to serve because one of the things that drives me is giving back to community. And I look at this opportunity as a way to define public service, to do it on a much more defined and higher scale. I was brought up with a very high sense of giving back to community, to the extent that sometimes we'd fix a public road and, you know, it's a local authority that's supposed to fix it. And we understood that we don't exist in a vacuum, but when you get certain competencies and skills, you need to find a way in which you can give back to community. So I believe that the experience and the training I have gotten over the 17 years that I've been in the legal profession, I can use this to give back to society as a judge of the High Court of Kenya and to serve Kenyans at that position. So that is my driving force, really to serve public service.
Yeah, but you see, one may say that's a generic answer because you can serve in many other ways, not necessarily as a judge.
Yes.
And even where you are, you're still serving, you know, when you lecture, when you give your advocacy skills, when you consult, that's still service, you know. So, you know, I'm still not getting, when it comes not specifically wanting to cross over to becoming a judge.
Yes, ma'am.
What is it?
Yes, apart from service, I also feel where I have reached in my career, I have something that I can contribute in terms of developing jurisprudence. I find that a very interesting space that I would like to be in. I've been inspired by judgments and rulings of people like Justice Mumbi Ngugi, who started the whole debate about structural interdicts. And I want to be that judge who develops jurisprudence, who develops the law, who moves, who helps us break free from what I would call unprogressive precedent and develop a country through jurisprudence that the Constitution...
Particular area, you know, very specific skills in one particular area, not being all over the map. Nothing wrong with being all over the map, you know, people are different. Now, which brings me now to the question, you see, I'm struggling to understand, with tremendous respect, and
yes.
I'm not saying there's anything wrong with that,
Commissioner,
which is your area of specialty, where you feel, well, grounded? Because I see in your CV, you seem to be in consulting. You know, there are various consultancies that I'm seeing you've been doing. You are teaching, you know, various institutions of higher learning, which again is all right. Again, you know, advocacy, where you know, doing advocacy, but also at the same time also litigation. So I don't seem to get where exactly is your skills being applied in a very specialized manner, in line with what I just told you about how to lead.
Yes, yes, Commissioner. I would say in academia, I have focused a lot on constitutional law and human rights. And that is a space that I do my academic work. When it comes to practice, I have specialized in dispute resolution. So I've handled multiple types of disputes in statutory tribunals, in our magistrates' courts, in the superior courts. And so I still see myself as a person who has focused on key areas where I'm able to give my best, Commissioner.
So, which leads me now to the final question. If somebody was asked to define Dr. Hakula,
yes,
will you be defined as an academician? Will you be defined as a litigation lawyer? Will you be defined as a consultant? What is it that somebody will describe you as in one sentence?
A legal practitioner.
All right.
Yes.
All right. That's all.
Yeah.
I'll take that conversation further by bringing you squarely to the High Court where you practice. And as you have been told, this is a very complex job, or should I call it a calling, because you will have to work beyond the call of duty. When we engage the stakeholders, they told us to look for actually a tractor, and we want to know whether you are that tractor. Yes.
My lady, I didn't quite get your question.
Yes.
You said stakeholders.
Yes, the stakeholders told us to look for a tractor.
A tractor.
Because of the complexities.
Yes.
That you will face in the High Court. So let me be specific. There are many types of jurisdictions exercised in the High Court. I want you to give us 5 key jurisdictions of the High Court.
Now, my lady, the first one is appellate. The High Court is an appellate court. The second one is the court has both unlimited original jurisdiction in civil and criminal matters. It is a constitutional court. It interprets the Constitution. It is also a human rights court in the sense that it enforces the Bill of Rights. It is also an election court in cases where statute has given it jurisdiction to do so.
Okay, I'm happy with that. Another area that we are challenged is the protection of rights, of the fundamental rights, and we would like to hear from you the areas where there are challenges in accessing justice to protect those fundamental rights, and what you would do as a judge to ensure that there is confidence in the judiciary.
I think, first of all, one of the biggest challenges in our Constitution is breathing life into Article 43, which are social and economic rights. These are rights that directly improve the lives of Kenyans. Rights such as health, rights such as education, clean water, etc., etc. As a judge, then I would seek to give life to these provisions in appropriate cases, I would seek to come up with jurisprudence that breathes life into that part of the Constitution. I know that enforcing those rights sometimes involves other stakeholders in government or other arms of government, and that has been the dilemma, to the extent that internationally some countries have said those are not human rights. But in our country, they are in our constitution, they're justiciable, and therefore as a judge I will find creative means to ensure that the other arms of government that are responsible for example, creating policy that will give life to these parts of the constitution actually do their bit through my rulings and judgments. The second thing is...
how do you engage them for purposes of enforcement of your orders?
I think one of the ways in which these orders can be enforced is through structural interdicts, where you allow the appropriate arms of government to go and formulate policies and report back to the court after a given period, and the court will assess whether those policies are actually reasonable or not. So you apply the reasonableness test.
Okay.
The second thing that I would do is I would ensure that each and every Kenyan has access to the courts. And so if it's somebody who comes to court and they're not represented, I would find a way, because sometimes I've seen the dilemma in courts is that you have this old lady who is trying to articulate her issues in court, but she does not know how to present her case. She doesn't have the technical expertise that a lawyer perhaps has to design pleadings and present them before a court for determination. So I'll be very sensitive to such things and see how best I can assist Kenyans who need help to access a court for purposes of justice. I will not be quick to close the door because they have not come in the proper way, because they have not filed a plaint, but I'll find a way of opening the door so that they come in and have their issues articulated. Even if it's to find a working relationship with an NGO that supports people who need legal services, would create those partnerships. And I believe that reading your vision, my lady, you want judges who will be able to create local solutions to local problems. So I believe that I'll be that judge who would find a local solution to a local problem.
Thank you very much. The next set of questions will be asked by Justice Majanja.
Thank you, Chair, and good morning once again.
Good morning, Judge.
You said you practice in Nairobi and Bungoma?
Yes.
Have you attended a CUC meeting in Bungoma?
I have not attended a CUC meeting in Bungoma, but...
have you attended a bar bench meeting in Bungoma?
No, I haven't.
Have you attended a CUC meeting in Nairobi?
Nairobi, my associates have. I haven't done it.
Have you attended a bar bench meeting in Nairobi?
No, I haven't, Judge.
Okay, don't you find that very strange?
Sometimes because of the exigencies of work, I would want to delegate, and the person who attends the meeting would come and report back to us.
Okay,
yes.
So let's look at Bungoma.
Yes.
Who is the presiding judge of Bungoma?
It's Justice Koome.
You are sure?
Yes.
And since your delegates report to you, what is the most pressing issue in Bungoma locals now for advocates?
The issue of backlog.
Apart from backlog, it's a common issue.
Another issue is sometimes we experience problems with the CTS system, where perhaps it's not functioning for a day or two.
Okay.
And maybe we have
another issue that is peculiar to Bungoma locals.
I think another issue is sometimes we have cases where there's no progress being done because lawyers are not proactive on their cases. For
example, you've not had complaints about the state of the buildings in Bungoma locals. That has not been an issue.
It has been an issue.
So you want to be a judge, yet you have not been following up issues that concern administration of justice.
I think I have not been very keen on that in terms of because I I mean, I haven't gone to the courts to see what the issues are. I can say, Commissioner, I have not been very keen on that.
Thank you. I have no
Yes.
further questions
Yeah.
for you.
Thank you.
Thank you, Honorable Chair, CJ. Daktari, Council,
Yes,
I
Judge.
have a few questions for you.
Yes, sir.
I have basically looked at your writings. There are quite many of them are the ones that relate to your thesis and so on. They are very academic. I'm also interested in the your sample writings in respect of your pleadings and also your submissions. I find that from a lawyer standpoint, you have done them very well. They're structured and to the point. But now you will be asked to be writing rulings and judgments, orders and decrees, which are quite a different ballgame. What is the difference between a judgment and a ruling in terms of definition?
Thank you, Commissioner, for that question. A judgment is a final pronunciation or pronouncement in a matter. It finalizes a matter. And once a judgment has been issued, the court is functus officio unless the parties come back to the court with an application for review. Meanwhile, a ruling is what I would call a part judge because it deals with an interlocutory matter within, it does not fully discharge the matter. It deals mostly with interlocutory applications. Yes.
During the proceedings?
During the proceedings. Okay. Yes, that's
Yes.
the difference.
If you become a judge and you've had a matter, looking futuristically, how would you intend to structure your judgment? What are the features of, during the construction of a judgment, what are the main basic features of a judgment?
The basic features of a judgment include one, the introduction, where you cover the background of the dispute. The second part is where you analyze the submissions of the parties, or you also analyze the evidence that was presented, you analyze the submissions of the parties, then you proceed to analyze the law as you do your disposition. You compare the evidence, the pleadings and the issues that arose. At that point you have already identified the issues, and so you connect them to the law, and then you come to your conclusion where you make your pronouncement.
Okay. Yeah. Now when you are writing, during the course of writing the ruling or judgment, who are you intending to communicate with? But initially and in finality.
I've had cases where clients have come to my office, especially in Bungoma when we are serving clients who are from the village. And the reason why they come is they want us to read a judgment for them because it is too technical. So in my understanding, I think a judgment, your audience is actually just the Kenyan in the streets. That is your primary audience. The litigants themselves, the people who own the case, most likely it's just normal people who perhaps have a very average education. So you must be able to write a judgment that that person can read at least and get a basic understanding of what the court is saying. Judge, to answer your question, I think my primary audience would be the mwananchi in the streets.
Yes.
Yes.
You are an academician at a very high level. Would you be able to write simple, clear judgments that have that impact, that they talk to the litigants and finally to society?
Judge, I believe I am able to write those kinds of judgment. Because even in academic writing, you must understand your audience and write something that your audience will be able to understand. So if I am writing a paper for LLB students, I would use a different kind of approach if I'm writing a paper for, so you must understand your audience. And Judge, I believe that I'm able to write and communicate clearly to my audience. Yes.
So you not use the legalese language, null and void ab initio, and
they are not necessarily bad words, or I would use the language, but again, I think after saying void ab initio, for example, to use what you have said, I would break it down further to just say what I mean. and say, break it down so that it doesn't stop at void ab initio, but break it down in English, simple English, for somebody to understand what that means.
Thank you very much. I wish you all the best.
Thank you, Commissioner.
Thank you, Chair. Good afternoon. Good morning, sorry, Council.
Good morning, Commissioner.
Okay, I have a few questions for you. Why do parties in a civil case intend to amend their pleadings? What would be the intention of parties in a case the intention of parties to amend their pleadings?
Commissioner, thank you for the question. Most of the time it would be to bring in an aspect that was not captured originally when the matter was filed. So an amendment would seek to correct an issue that was not captured. Sometimes certain things have changed within the dynamics of litigation. For example, we filed pleadings to stop an auction. The court refused to give us an injunction. The auction happened. We'd need to amend our pleadings so that now we see how to get justice. Perhaps say we want compensation for the property that was wrongly auctioned. So those are some of the reasons as to why parties would amend their pleadings.
Okay. Now we have two conflicting decisions from the High Court with regards to whether you can amend an application. Which one would you go for? You can't amend an application, or you can amend an application and give your reasons?
I think I would go with the school of thought that it is not good practice to amend an application.
Give the reasons.
The reason for that is that an application is an interlocutory proceeding before a court. And so if there was something that you did not capture in your initial application, I think the proper thing is to withdraw it and just file a proper one. There's also been a debate on whether an application is actually a pleading.
You're giving us your response.
Yes.
It's for you to now.
So for me, I would go with the practice of withdrawing and filing a proper one.
But your initial question, your answer to the question, why do we need to amend our documents? It was more of clarity. So you don't think at times you may need to clarify something that you have left out in an application?
You may need to do that. I agree with you.
So your response is, can you amend an application, or you cannot amend an application?
I believe you can file a proper one, capturing what you had missed out.
So you withdraw and file a proper one?
Yes.
Okay. So what are the three essential elements of the offense of obtaining by false pretense?
The essential elements would be, one, that a person purported to be, presented himself as being able to give you a certain kind of service. Number two, they received some consideration. And number three, they did not deliver.
Are you sure about that? You'll have to read.
I may have to check on that.
Okay.
Yeah.
Lastly,
I may have to check on that.
When the Chief Justice asked you a question with regards to what you would do to enhance access to justice, you mentioned that when a party appears before you and they've not filed a plaint, you will ensure they get legal representation. Take us through how, as a judge, you will ensure that that party who has not filed a plaint gets legal representation.
One of the ways that I can do that is to raise the issue, for example, in a bar bench meeting or a CUC meeting, and perhaps have a conversation with lawyers who practice within that station and request some of them to take up such a brief to assist this person to be able to access the court. I have had an experience in court where, I can't remember the name of the judge, requested me to help a litigant who could not articulate their issues to court, to find a way of helping them. And indeed, after that court session, I was able to help this person to draw whatever document they needed to draw. So I would engage, I would do that. I would use that strategy. Look at the available resources around me and
so you'll engage a bar bench meeting, reach out, the lawyers say they will not be able to take up that matter pro bono. They are no longer interested, they want to be paid.
I believe lawyers, I cannot miss a lawyer who will take up the matter, because I practice and I know that most of the lawyers out here also they would want to give back. So I don't entirely believe that all the lawyers will say we cannot take up this matter.
So would you document in your file the proceedings? Because I don't even understand how a person who has not filed a plaint, there will be a file before you with no plaint. Because that is the example you cited. A person who is not able to file a plaint, I will refer that person for legal representation.
That was just but an example. Perhaps it was not very accurate, but perhaps what I had in mind is there are certain suits that would require specific pleadings to be filed. For example, if they were required to file, let's say, an originating summon, and they have come by way of plaint, or vice versa, and I have identified that that is the problem, then of course I would have a file before me, and if it's a person who is representing themselves, then I will tell them that the process in which you have used to come before the court is wrong.
Are you sure you are allowed by law to tell a party who has wrongly come before you in an adversarial system that you ought not to have come by way of a plaint? Go and look for a lawyer to bring the necessary pleadings, the correct pleadings, not by plaint, by originating someone. You are allowed. How are you supposed to communicate with parties to a suit?
And I'm using an example of a person who is representing themselves.
Still a party to a suit?
A party to a suit,
yes.
Yeah. And I'm getting my inspiration from Article 159 of the Constitution, where courts are required to exercise substantive justice. You know, look at how a dispute can be resolved, rather than being fixated on procedural technicalities. So I would find a way of communicating to the litigant.
That is what I'm asking you. How do you communicate as a judge?
Yes.
How are you expected to communicate?
Commissioner, I think I may need to think about that.
Okay.
Yeah.
Thank you.
I may need to think about the issue of communicating. But I believe there is a way in which I can communicate.
But how are you expected as a judge? You know, that's what I'm trying to get you to give us a response.
Yes.
How are judges expected to communicate?
The judges are expected to communicate primarily through their rulings and judgments.
Thank you.
Yeah, that is how they're supposed to communicate.
Thank you, Chair, and welcome again, Andrew. Now, could you explain how the role of the judge today has changed from that of a traditional judge, as we have always known it?
I think the judge today is required to be very sensitive to the fact that justice, one, is about people. The judge today needs to be connected to the ongoing things in the community. The judge today needs to be technologically savvy. They must be able to leverage on technology for efficiency. The judge today, I think those are the ones that stand out for me. Yes.
Okay. Finally, could you explain to us the independence and the interdependence, three arms of government, how they work independently and interdependently?
So when it comes to the independence, let me use the independence of the judiciary. It means that the judiciary is not under direction from other arms of government. It means that judges and magistrates and judicial officers have discretion to deal with matters without taking instructions from anyone. They have to pay due regard to the law and make decisions. However, when I look at the constitutional architecture that we have in this country, we cannot then say that the judiciary is 100% independent, but would rather say that the judiciary collaborates with other arms of government to achieve the broader objectives in the constitution, which is delivery of justice to the people of Kenya. So there's a level of interdependence, and I'll give a practical example that the judiciary has to go to the National Assembly to approve funding to be given to the judiciary. So that's a level of interdependence. I also see interdependence within the NCAJ, which is a body that constitutes different stakeholders in the justice sector, some of them from the executive, some from the legislative arm of government. And so the idea is that justice is a concerted effort. So as much as there is a principle of independence, our constitution also creates a framework through which all these different arms of government must collaborate, must work together to achieve certain constitutional objectives. Yeah. Yeah.
Thank you, Chair. Good morning once again.
Good morning, Commissioner.
You currently have a law firm, one in Bungoma and one in Nairobi. You said you have some associates. About how many? In both offices? In total?
In total.
Yes.
I work with 4 associates.
4 associates?
Yes.
And staff members, roughly how many?
Staff members, we have about 12.
12 staff members.
Support staff, yes.
Do you have a performance measurement framework in your law firm?
Yes, we designed something last year where we set goals. We agree with the different process owners that this is what we want to achieve, and then we review the goals after a year.
How has that seen performance in your law firm?
It has enhanced performance in the sense that people feel directly accountable for certain things, and it has pushed those who did not want to improve themselves to actually improve because they know that they're going to be assessed. And at the same time, we were able to see productivity. We're able to gauge somebody's productivity. We're able to also stir a culture of improvement in the way that you do your work. So it has positively impacted our deliverables. Yes.
What other way has it benefited the firm other than improving productivity and motivating staff to work?
It has also improved our revenue. Because for me, like the lead partner, I also set goals for myself. So last year, some of the goals that we set were to bring in X number of clients, and I think I did like half 50% of it, and I was happy with myself that I was able to set a goal and at least deliver.
For a moment there, I thought you were going to quote figures of
no.
the amount of money that it has brought in. Yes.
Yeah.
It also helps to give information on areas of improvement and how you can support your staff.
Correct.
Yes.
Some of the areas that we have identified out of that process is continuous training for the staff. So we've identified certain areas that we must get experts to train us this year, for instance, where staff have said, yes, we do these assignments, but it seems like we have gray areas on ABCD and would like to improve our competence.
Okay, great. Now the second question I want to ask you, in a criminal case, how would you go about pre-trial case management, and what would you be looking to achieve?
I'll start with what I'll be looking to achieve. What I'll be looking to achieve is to get the matter ready for hearing. Now the process.
Always?
Yes, to get the matter ready for hearing. But also the second aspect to that would be also to see whether the matter can be resolved out of court.
Okay.
Yeah.
So how would you go about it?
So I would first of all ensure that we have all the documents that are required to be filed, that is witness statements, exhibits, etc., etc. We know how many witnesses are being called. We know whether there are any experts that are being called. Perhaps we even get an indication of how long it will take for all these witnesses to be heard. And I think so once we've done that, then we have a clear way forward on how the matter will progress after that.
Okay, I will take that. I want to give you a scenario, a practical scenario, and I hope you will give us practical solutions to what you may find yourself in if you are ever to make it as a judge. So you are appointed a judge, and you're posted to a station where you find that you are the only judge, and you have to handle all cases. It's only in Nairobi, I think, and some major stations where we specialize, but mostly in the outpost stations, you'll find you handle everything. So you find in your docket you have about 4,000 cases. About 50% of them are already backlogged, dating back to over 3 years. So how would you go about addressing or handling these cases, bearing in mind that we are backlog clearance is one of the issues that we are grappling with?
Yes. Thank you, Commissioner, for that question. When I report to that station, I believe, I haven't used the CTS from the judiciary's end, but I believe in that system I'm able to log in and see how many matters are allocated to me. I believe that the system is able to, for example, generate a report with an aging
yes, I've already given
statistics.
You have 4,000.
Yes, I have.
Seen it in the system.
So
you have 4,000.
what I'll be looking for is to sort of understand which files are very old among the 4,000. I will focus on that, on the older files, perhaps the ones that are older than 3 years. Focus on them. I will want to find out why these cases are not proceeding. I will want to find out why the advocates are not taking dates for hearing. So if it's an issue that perhaps pretrial has not been done, I will focus to get that done. If it's notice to show cause. When you say focus,
you know you're speaking in a very general sense. When
yes.
you say focus means what?
Focus is basically ensure that the process of pretrial begins. We put a date on the matter. If the date has not been taken by the law firms concerned, we'll issue a notice.
Yes.
That this matter is coming up for mention on a particular day for purposes of pretrial. On that day, I anticipate that a lawyer might come and say, this matter was resolved. I anticipate that a lawyer might come and say, yes, we are ready to take pretrial directions, so give us another 14 days to put in our bundle of documents, our witness statements, etc., etc. I anticipate that another lawyer might come and say, this is a matter that looks like can be resolved through mediation. And I would even prompt and ask whether this is a matter that can go for mediation. If it's one of those, we'll refer it for mediation. I anticipate that there are matters that can also go to AJAS, which I will facilitate the process, and then get the system running, you know. If it's a matter that needs to be heard, then we prioritize the hearing and get it heard. We make sure that we have all the bundles of documents filed, witness statements, and so when it comes to hearing, we are not taking a lot of time, but we are making progress on the matters. So that is the focus you will give the old cases, the 50% yes. I've told you? Yes.
Yes. So what happens to the new ones?
The new ones, I would also seek to look at the nature of these cases. Some of them might have some interlocutory applications that perhaps can be dispensed with without necessarily writing rulings and judgments. So we'll have that engagement with counsel in court. So in situations where, for example, we can agree that let's have an order for status quo and let us focus on the hearing, we'll prepare the matter for hearing and get it moving. If it's a matter that indeed needs me to sit down to write a ruling on an interlocutory application, then I'll ensure that parties have filed their submissions and we are ready to, I'm ready to write a ruling or in the matter. Those are the strategies that I would employ, because when I look at when I think about 4,000 files, I don't look at them as bulk 4,000, but I need to understand what exactly is in this 4,000 files. Yeah, and
so
when I get into
all that, you find you have about eliminated about 3,000.
Yes.
I mean 1,000, so you have 3,000 pending.
Yeah.
1,500 new, 1,500 old.
Honorable Commissioner, as court proceeds, then I will be very firm about proceeding. I will not entertain a lot of adjournments.
So you'll proceed with them simultaneously?
If my diary allows me, I'll make sure that each matter proceeds on the day it comes up.
Okay.
Yeah.
Lastly, if you are successful to become a judge, you will find your life will change somewhat. Your social life will be more restricted. You'll be expected to work in the evenings, late in the night. You'll be expected sometimes to work on weekends and even when you're on leave, because of the scenario I have just explained to you. If you're going to be handling the old and the new simultaneously, you will find you're forever having files everywhere you go. You'll be expected to accept probity into your life, your financial status. You are forever declaring what you have acquired, what you own. You'll be expected to lead a very restricted life in terms of the friends that you keep, to be accountable to what your family members do. You may find that you are transferred away from your areas of comfort. You probably operate majorly between Nairobi and Bungoma. You may find yourself in Malindi. Are you prepared for that kind of life?
Commissioner, I am prepared for that kind of life. I understand the nature of this office and what it comes with, and I have done a self-assessment. I have reflected. I have talked to some of my mentors in the profession, and in my mind I'm clear that I'm judge ready. I'm ready to take up the assignment and work. I have spoken to my family about the possibility of life changing, and we are aligned, Commissioner. I understand the depth of this office and what it comes with.
So you're all prepared to make the sacrifice?
I am judge ready.
Thank you. Thank you, my lady.
Thank you very much, CJ. Wakili, now the responsibility you are asking for will include leadership of other professionals. I would like to know from you in your career, what can you describe as your key achievements as a leader, that is, specific achievements that can be attributed to you?
As a leader, I think one of the things that I am proud of is the fact that I am a team leader in my place of work, and we set goals, we achieve goals. I have managed to inspire people to work. Honorable Commissioner, people get paid at the end of the month because we all work. So I believe I'm proud of that as a leader, that I'm able to put together a team of people who are able to get aligned and achieve certain objectives. I'm able to inspire people to work. I am also visionary in the sense that I'm able to see what we are doing in the short term, in the long term, and prepare the team to handle the long term. So I think those are the qualities that I would bring as a leader.
I wanted the specific achievements that can be attributed to you as a leader. Specific achievements.
Yes.
Do you have any?
And the specific achievement that I've talked about is I run a law firm that pays people's bills. I support families in the law firm. Yes, and I think if I wasn't a good leader, then I don't think I would have even people working with us in the team. So I call that a specific achievement as a leader.
Okay.
Yeah.
What would you term your leadership as? Is it visionary? Is it also then transformative? What is it?
First of all, I'm what I call a servant leader, in the sense that I would be on the front line doing the heavy lifting. I am also a visionary leader because I am able to predict outcomes and trends within perhaps the industry, and also create strategies that would enable us to do even better. So in that sense, I am visionary.
As a transformative leader, do you have any specific activities you have undertaken that can show that transformative skills?
I have I just want to say that I have also been nominated, and I've received awards within the profession. For example, last year I won an award for legal journalism award. Legal journalism award within the legal profession for my publications and writings. And I think that is transformative because I'm also on the front line when it comes to publications and research and writing. I have also recently published a book which I submitted as part of my sample writings before this commission, a book on social economic rights. I don't think there's anyone else who has written a book such as that in the country currently. So I look at these achievements as transformational.
Okay, thank you.
Thank you, Honorable Chair. Daktari, in Chapter 6 of the Constitution, what are the guiding principles of leadership and integrity?
The ones that I can remember are that leadership is about the people. It is a position of trust, and therefore one must exercise leadership with that in mind. The other attributes are integrity, transparency and accountability, involving people in the process of decision making.
Guiding principles of leadership and integrity. How is integrity one of them?
Sorry, Commissioner, I think they might have flown off my mind,
okay.
But I have read Chapter 6.
Do you know the reasons that are grounds for removal of a judge? Please give us those.
Incompetence is one of them. Corruption is another one. I think a situation where the judge is unable to function in the office of a judge or give the function in the office of a judge. I think those are the grounds. Gross misconduct, a violation of the Constitution. Those are the ones I can remember, Commissioner.
Okay. All right. Thank you. That's all from me.
Thank you very much, Counsel Dr. Akula, for engaging with us this morning. That brings us to the end of the interview, but we always give a candidate an opportunity to say something or ask a question.
Yes, first of all, I think I would just say thank you very much for allowing me to appear before you today. Indeed, it's been an honor. I had a suggestion to make in regard to how to even leverage on technology to make our processes better. I was thinking about using artificial intelligence to do Order 11, which is pre-trial, so that we free our deputy registrars, we free our judges from that activity. I believe it's something that can be programmed where lawyers can put in answers to questions. Have you filed your witness statements? Yes. Have you uploaded your bundle of documents? Yes. And then AI generates a certificate and we move to other processes.
That's why the judge was engaging you on why you are not an active member of the bar bench and the CUC, because that's where you give those suggestions, so that the particular stations where you're working, they can engage with the AI to make themselves more efficient. But that's a good idea, well taken, and the advice is that please take it to the court user committees.
Thank you.
Yes.
Thank you, my lady.
Thank you for your time.
Thank you very much.
We wish you well.
Thank
we
you.
will get in touch when we complete the process.
Thank you very much.
All the best. Keep up the good work
Thank you.
that you do with your law firm in